Hello, good morning, guys. Good morning. I hope you guys are doing great. Surprise. Yeah, I usually don't post when I'm going to be on live, but just make sure you have your notification bell on and you have liked and followed my page so that you will see all my live videos. As usual, we're keeping it short and sweet this morning. I have a meeting very soon, so we're just keeping it really limited. So I came across an issue and I just wanted to discuss this with you guys. So we're going to talk about evidence, what type of evidence you have to submit for any type of US immigration application. What is the type of evidence? What must it look like? What should the features of the evidence you're submitting be? Okay, when we talk about evidence, it just means anything that will prove something. Okay, any type of document. So the evidence can be testimonial, it can be documentary evidence, and they must be intended to prove something. Okay, very simply. Guys, drop me a comment. I'll be reading comments soon. Okay, so the first thing in when you're filing any type of US immigration application, you must first of all understand what the specific elements required are in order to demonstrate that you are eligible for the request you are seeking. Okay, so it's just like let me give this mundane example. You, in anything in life, to be able to make the request, you have to be eligible. So you cannot go and ask somebody who's not, let's say, your wife for sexual intimacy. You are not eligible to make that request. Okay, so the first rule is that you need to understand what the specific elements are that will show that you are actually eligible for the benefit request. So the one example related to immigration would be if you're filing for citizenship based on being a green card holder or a lawful permanent resident for 5 years, you can't apply when you have just been a green card holder for 2 years. You are ineligible. You need to apply from the 5-year mark. Okay, so that is one specific element to demonstrate eligibility for US citizenship under that rule. If you are filing for US citizenship on the basis of being married to a US citizen spouse, then your time frame is 3 years. You should have been a green card holder for 3 years. So demonstrating eligibility for that benefit means that you need to first of all prove that you are indeed married to a US citizen, and then secondly that you have held your green card for a period of at least 3 years. So understanding these specific elements will help you and guide you towards what type of evidence that you need to submit to the adjudicator who will be reviewing everything for them to say that, okay, indeed, this person does qualify. Okay, guys, drop me a comment. Let me see who's in the house. Sujan Bandari says, hi. Hello, Sujan. Happy to have you here. So guys, we're talking about how to submit evidence, what type of evidence to submit. Number one, understand the specific elements. Okay, then secondly, you need to understand also the standard of proof that applies to the benefit request. Okay, in most of the instances, the benefit requester will have to establish under the preponderance of the evidence. So under that standard, it just simply means that you need to prove to the adjudicator that it's more likely than not that you, the requester or the petitioner or the applicant, you meet each of the required elements. Okay, so under the preponderance of evidence, it's a term of art, but it simply means that you are 50% more likely to be eligible. So let's take a look at an example where somebody meets a US citizen and gets married to the US citizen, a foreigner, an alien. What's US immigration law terms alien? It means the person is a non-citizen. The person is not a US citizen. And then they meet this person and then they get married and then they file a petition. The petition is going to be requesting that the US government will grant the foreigner a green card based on their marriage to the US citizen. And the assumption is that you are trying to let the US government see that your marriage is real, Okay, so what is the preponderance of the evidence? Whatever you submit, for example, if you submit birth certificates of 5 children born to both you and you, the petitioner, and the US citizen, I guess the preponderance here is clear that it's more likely than not that the two of you are in a genuine marriage and it's not for papers. Because, I mean, how likely is it that somebody will give birth to 5 children just for papers? I mean, I guess some people could go to that extent, but the normal average human being will only have 5 children with a man or a woman that they intend to establish life together. And that's the standard when it's marriage, okay? A marriage type of adjustment or a marriage type of green card. So when we say by the preponderance of the evidence, when they look at the evidence of the birth certificate of 5 children, what is the impression that the adjudicator will have? I think there's, they've established by the preponderance of the evidence that the marriage is bona fide, it's real. They did get married, not for the purposes of getting a green card, but they got married to establish life together. That's always a standard for marriage, okay? That you intended to establish or live life together at the time of marriage. So, guys, let me tell you this very interesting thing. Sometimes there are people who enter into these marriages, and the aim at the time of entry is that, look, I just need a green card, and you can supply me with a green card, and then they exchange money and whatever. And in the course of the relationship, they start hanging out, and then they realize that, okay, we're in love. So they get married with the intent that, look, it's just for a green card. And then something happens, they start enjoying whatever, and then you realize that, okay, they're in love, and now they decide, okay, we now want to establish life together. That is still categorized in US immigration law as a sham or a fraudulent marriage, because the test is at the time of entry into the marriage. If at the time of entry the intent was not to establish life together, it doesn't matter what happens after the fact. The crime is already committed at the point where the intent was not to establish life together, but only to get a green card. Okay, so that's that. And okay, so let's go to the last and third element. I'm about to leave you guys soon. So you need to, okay, so all the evidence that you're submitting have to be reviewed, and then you have to determine, if each of the essential elements has been satisfied by the applicable standard of proof. Okay, so the standard of proof applies to each element. It's not just a total of the elements. Every single element, you need to be able to see that the essential element has been satisfied. Each of the essential elements has been satisfied. Okay, so pretty much that. Let's see. So if the officer determines that the benefits requester is eligible for the benefits requested, that means that all the essential elements have been satisfied by the applicable standard of proof. Then you also need to show that the favorable exercise of discretion is warranted for your case. Then the officer will approve your application without needing to issue you an RFE, or that's a request for evidence, or a NOID, that's a notice of intent to deny. Okay, so I think that this has been quite short. Let me see if we can just talk about a couple more things here. Okay, so generally, if you are not able to establish that you have eligibility under the applicable standard of proof, then the officer will generally issue an RFE, that's a request for evidence, or a notice of intent to deny. Then they would request evidence of eligibility in that request. So let's talk about the RFE. So sometimes you'll have married couples will submit evidence of the bona fides of the marriage, and then there'll be an RFE. Like if, for instance, social media, let's say there's a man who's a foreigner, he's married to a US citizen, and they filed an adjustment of status application, and then he has his Facebook page open, it's not logged, and he says that, oh, he's married, according to US immigration law, he's married to Rebecca, who's a US citizen, but he has a woman who's from his country, let's say he's from India and his woman is called Priya, and on social media he has pictures of Priya. He's at parties with Priya, kissing Priya, and everything shows that, okay, that looks like a romantic relationship. But then with US immigration, you say that Rebecca is your wife, you may be issued an RFE, because well, in fact, in that case, if you may possibly even be issued a NOID, a notice of intent to deny, because that means that they've come across derogatory information about you, and you are being given the final chance to kind of explain what's happening. So yeah, be mindful of all these things. Sometimes it could even be just your sister and you're being silly or whatever. So just be careful when you file these applications. It's not only the evidence you submit that they are entitled to adjudicate. They can use any type of evidence, for or against you. Well, most likely they would, against you, because that's where it matters. When there's evidence for you, you need to make sure that you're submitting that evidence for yourself. You understand that, right? If the evidence goes in your favor, it's up to you to submit that evidence to them, that, look, hey, here's my strong evidence, look at it. Okay. So it's just like, something I heard somebody say, oh my goodness, this went off. Something I heard somebody say some time ago, that when you are poor, nobody investigates the source of your poverty, right? But then when you are rich, everybody tries to investigate what's the source of your wealth. That's kind of how it goes. When the information goes against you, they're going to bring it out and say, look, here's the information against you. But when it goes for you, they're not going to go around searching for information that goes, or evidence that helps your case, and then say, oh yeah, this is even true. That's your job. You need to submit that evidence for yourself, that, look, this actually goes in my favor. So here's the evidence. So let me read a couple of comments and then we can call it a day. Nana Akompi says, good education there. Thank you, Nana, for watching. Al Mustafa Abdul Kadri says, you married to US citizen and you divorced based on domestic violence. You get a 10 years green card. How many years can you wait to apply for citizenship? 5 years. When you're married to a US citizen, you can wait for 3 years. You qualify for citizenship after the 3rd year from the issuance of your initial green card. And when I say initial green card, it does not refer to the conditional green card per se. It refers to the subsequent green card, but essentially the conditional green card will add to the permanent green card. I don't know if that makes sense, but from the first issuance of your green card, it's 3 years if you're married to a US citizen. Okay, so if you got married in 2018 to a US citizen, and then you got you filed your application for a green card in 2019, then you're going to get a green card, a 2-year green card, because you got married 1 year. I'm sorry, you got married within 1 year of the application. I'm sorry, the meeting the people are in, so I'm a little distracted, but let me end it here. So if you're married to a US citizen and then you get divorced, you can no longer qualify on the basis of being married to the US citizen for 3 years. So you now have to wait for 5 years from the issuance of the initial green card. So if you were granted a green card in 2015, you wait till 2020, and then you can apply for citizenship. Yeah, sorry, I have a meeting the people are in, so I'm just a little distracted. So Jaza Mohammed said, I'm a US citizen. My fiancé is from Morocco. We're getting married October 1st, 2021. We have been together 16 months. We're already working on his visa and green card. Okay, great. All the best to you guys. I wish you guys all the best and congratulations. Thank you for sharing. Barbana Emmanuel says, thanks for the good work. Need your WhatsApp number. That's 802-7800-564. Please contact us on WhatsApp. Al Mustafa says, thank you for clarifying. I'm sorry. Yes, I was a little all over the place, but essentially, if you are divorced, you no longer qualify to file for a green card after 3 years of having your green card on the basis of being married to a US citizen. You still need to wait for 5 years. So after the 5-year mark, make sure you qualify you know, there are no crimes of moral turpitude, there are no bars to your citizenship, and you haven't been out of the country for too long, and all the other qualifying features. All right, friends, so I will see you guys later. I have to hop off to my meeting. We will touch base again soon, and I wish you a very wonderful rest of the day. That's my number right there, 802-7800-564. You can contact us if you need our assistance. Have a wonderful day, and bye.